Welcome to part 4 of our 4-part webinar series on some of the important issues which have resulted from the CFPB issuing its final collection rules. My name is Scott Best, and I'm an attorney with Weltman, Weinberg & Reese, working out of our Philadelphia office, and I am the primary New Jersey attorney. After listening to this information, we would ask that you complete the survey at the end of the presentation regarding interest in future webinars. Today's topic is restrictions placed under the new debt collection rules related to inconvenient time and unusual place. As you are likely aware, the CFPB has issued these final rules in an effort to bring much needed guidance and uniformity of practice to aspects of the FDCPA which have become muddied over the past 40 years. And while the final rule, like the FDCPA, does not apply to first-party creditors, to those of you who are first-party creditors, it can act as a best practices guide and may be applicable if your state has a state consumer protection law, which applies an FDCPA equivalent to first-party creditors. In the context of the FDCPA and inconvenient times and places, Section 805A1 provides that without the prior consent of the consumer or express consent of the court, a debt collector may not communicate with a consumer in connection with the debt collection of any debt at any unusual time or place, or at a time or place known or which should be known to be inconvenient to the consumer. In the absence of knowledge to the contrary, a debt collector shall assume that the convenient time for communicating with a consumer is after 8 o'clock in the morning and before 9 o'clock at night, local time at the consumer's location. Section 805A3 further states that the collector shall not contact the consumer at his place of employment if the collector knows or has reason to know that the employer prohibits the consumer from receiving such a communication. The rule found in Section 1006.6, subsection B, subsection 1, largely restates the FDCPA provisions regarding time and place. And while the comments to the rules go to great lengths in discussing what is inconvenient, the rule does not define what it deems to be unusual and does not provide any examples of what would be deemed to be an unusual time or place, just that communications at an unusual time and place are prohibited. So while they have tried to clear some things up, some issues remain open to interpretation. Of great significance, the final rule applies to all forms of communication, including phone calls, text messages, mail, and email. Any communication by phone, text, ringless voicemail, or email are presumptively inconvenient if placed before 8 a.m. or after 9 p.m. For purpose of anything other than a phone call, time of communication is determined by the time the collector sends the communication, not the time received by the consumer. For example, a text or email sent to the consumer at 5 p.m. but not viewed by the consumer until 10:30 that night is compliant. Additionally, a single auto-reply message in response to a consumer communication is compliant with the rule, as the consumer reached out to you during a prohibited time. This aspect of the rule takes into the account the modern practice of many people who set out-of-office messages to run when they leave work for the day. Obviously, penalizing someone for sending an auto response to an email sent by the consumer after 9 p.m. or before 8 a.m. is not the intended purpose of the time and place restrictions. The comments to the final rule also provide that if a consumer advises the collector that they are contacting them at an inconvenient time or place, the collector is deemed to have knowledge that all communications to the place, including mail and calls to a landline phone at that location, are inconvenient and prohibited. The scope of that can be limited if the collector asks follow-up questions which clarify what is inconvenient when would be a convenient time, a better method of contact, etc. Unless otherwise indicated by the consumer, text and email communications can continue as they are not associated with a place, unless the collector knows a consumer will be at that place when the communication attempt is made. Additionally, once the consumer indicates that a collector is contacting them at an inconvenient time or place, the collector must cease the communication with the exception of asking follow-up questions. The CFPB has also clarified that the consumer does not need to use the word inconvenient or other similar trigger words to express that the communication is at an inconvenient time or place. But some of the burden does shift to the consumer to be a bit more specific than saying, don't contact me here, without saying where here is, such as school or a doctor's office or wherever it might be. It instead provides examples of what a consumer needs to indicate to show that a particular time or place is inconvenient. Examples that they provide include, I cannot be disturbed on Tuesdays and Thursdays through the end of the year. However, without additional clarification, terms like I'm busy right now, I can't talk right now, does not indicate that the time or place is inconvenient going forward. Should the collector ask additional questions and the answers indicate that the time or place will be inconvenient going forward, then the right now aspect is removed and the general prohibition will apply. The comments provide an example that a consumer states they cannot talk now, to which the collector then asks when would be more convenient. The consumer responds on weekdays except for from 3 to 5 and weekends. Based on that, the collector knows or should know when they can contact the consumer. However, without asking the follow-up question, the prohibition is limited to that one call or communication, and there is no rule requiring that the collector ask whether the time or place is convenient at the outset of a communication, as asking that during every communication would be very impractical. If the collector, however, notices a pattern and is contacting the person at that same time of day or day of the week and are continually told, not now, then the prohibition regarding should know and that provision will apply, and the collector should not attempt further communications at that inconvenient time. Should the consumer then contact a collector at a time or from a place the consumer previously designated as inconvenient, the collector can continue that communication. Or if a voicemail, text, or email are received, the collector may respond once, but the consumer-initiated contact is not a general waiver to start contacting again at that time or place. Once responded to, the prohibition is back in place. Importantly, the reply must be through the same method of communication used by the consumer in contacting the collector. So if the consumer contacts you by email, you must respond via email. If they call you, you cannot then email them or text them or do anything. If they call you, you must call them back. Finally, under section 1006.6, subsection B, subsection 3, largely adopts the FDCPA language regarding contacting consumers at work. You cannot contact a consumer at work if the collector knows or should know that the consumer or that the employer prohibits these communications. But there is no requirement that the collector keep a database or a list of employers that prohibit contact, as again, that would be very impractical. The final rule commentary states that prohibition of place of employment contact is limited to employer-provided cell phones, emails, or landline phones. It does not apply to contacting a consumer's personal cell phone while they are at work. However, the cell phone limitation is subject to general inconvenient time or place restrictions discussed previously. So if a consumer says that they can't take calls on their cell phone while at work, the call must end unless it is to see when a better time or place for contact would be. The final rule provides a safe harbor to allow for compliance when there is conflicting or unclear information regarding a consumer's location. This is in large part due to the account for the mobility of cell phones. However, the commentary states the best thing to do if you have someone with a New Jersey cell phone, for example, but listed as possibly living in Washington State, your contact limitations should be based on a combination of the two times. The example would indicate in this instance that you can't contact the person before 11 a.m. Eastern Time due to the possible location in Washington for the morning hour limitation, and you are limited to the 9 p.m. Eastern Standard Time to account for them possibly being in New Jersey for the evening hour limit. Obviously, these are very fact-specific instances and will be largely determined by what a collector or a creditor knows or should know about the location of the consumer. Finally, the final rule in its commentary does not put a requirement that a consumer's prior designation for an inconvenient time or place be transferred to a collector by a first-party creditor or by a prior collector who might have been working the account. However, if the collector knows or should know the designation, it must be honored. So if you are a first-party creditor and a consumer tells you between 12 and 5 are inconvenient, and you forward your account with the account notes to a collector, they are then on notice of the restriction and must comply. If you are a collector and your client sends you their account notes, you must now review them for any restrictions before attempting a communication. Going forward, it would be recommended to develop a policy and procedure on how to notate this information and how to alert a collector of this information when transferring a file and transferring that information to them. Should you have any questions regarding what was discussed during this presentation, please do not hesitate to reach out to our office and kindly complete the survey at the end of this presentation with regard to future webinars. I thank you for your time and have a good day.